Learn more at attypip.com.
Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open, and we're open to serve you, help you in any way we can. All you have to do is to call the toll-free number. If you have a legal question, you have a toll-free number, 877-943-9673. We take questions every week to help you, get you pointed in the right direction. If I don't know the answer, I'll quickly tell you I don't know, but always have a resource of some type to help you, or I'll find the answer out myself for you. Your question can be about wills, trusts, probate, power of attorneys, family law, real estate law, just about personal injury. It can be just about any area of law, Medicaid, VA benefits. Be more than glad to help you. To start the show today, we have attorney Patrick Smith from our firm on to talk to us about the probate tip of the week. And we also had an interesting question come in this week about probate. And good morning, Patrick.
Good morning, Joe. Happy Saturday.
Happy Saturday to you. Is it going to rain today? I guess it is. Probably.
Oh, yeah. Yeah, over here, guaranteed, for sure. It's already clouding up.
All right, so a question came in. Actually, it was one of your clients had this question. He had a friend die. The neighbor had, a expensive house. Not sure what other assets he had. He had no spouse, no children, no siblings, no relatives of any type that the friend knows about. His house is just going to sit there forever unless somebody does something. So what can he do, and what normally happens when a person without existing known family members passes away?
Yeah, so in this particular case, any interested party can petition to open an administration for a decedent, if nothing else, in an effort to preserve the assets for the beneficiaries. And since this particular gentleman was a Florida resident, he qualified to serve as personal representative for the neighbor. So he could petition to open the estate to preserve the assets while the beneficiaries are located. And in the absence of an estate plan, that may take a little more time because it's going to go by statute, which under the intestacy rules, it could be any random set of beneficiaries that may take a certain amount of time to identify.
So normally in this case, how would you go about finding the possible heirs, and who, if there are no children, no siblings with children, who would be next in line to receive the estate, and how would you find those people?
So I've had this case a few times, and believe it or not, when people have money coming to them, oddly enough, they find you. So oftentimes it's not as difficult as you think. But in those circumstances where they're not as forthcoming, we usually bring in the services of a private investigator, and within a few days, maybe a week or so, we've located the appropriate beneficiaries.
All right. Any other tips about probate you'd like to share with us before you?
Yeah, this is all highly avoidable. If you do a proper estate plan, all these unpredictable outcomes are 100% preventable by having a proper will or trust in place, so I encourage everyone to do so.
Patrick, I'll give out your contact information during the show, but thank you so much for starting our show this morning.
Joe, we appreciate you. Have a great Saturday. Good luck with the rest of the show.
All right, thank you. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, if you'd like to call this morning, love to talk to you, get you pointed in the right direction. Come in just to help you, actually. We have a 52-minute straight run, no commercials on this show. No commercials at all. And our sole purpose is to help as many people as we can during our 52-minute run. 877 is the toll-free number, 877-943-9673. Let's go to Michael in Jacksonville.
Hi, Joe. Good morning.
Good morning, sir.
Hey, I got a question. Can the county tax you, take money from your Social Security if you owe property tax?
Can the county take your, there's Florida Statute 222 that's exempt, that certain assets are exempt from creditors. So creditors, including the government or the county, maybe not the IRS, that might be an exception for the IRS, can take almost anything, cannot take your homestead, now they can foreclose on your homestead, but they can't, a creditor can't otherwise take your homestead or Social Security or retirement accounts or insurance or annuity products. There are a certain level of assets under Florida Statute 222 that are exempt from creditors. And Social Security is one of them, and retirement benefits, and disability benefits.
Okay, thank you so much. I appreciate you guys. Thank you.
All right, thank you. You're listening to Ask an Attorney, all about Florida law, and I'm Attorney Joe Pippen, practicing attorney. The law office is open early this Saturday morning, first weekend in March, and we're here to help you in any way we can. You have a toll-free number, 877-943-9673. And let's go to Andy in Tampa.
Hey, good morning. My mother passed away about a month ago, survived by my two sisters and myself, and one of my sisters is the executor, I guess, of her will. She had a will. It was pretty simple. She really didn't have much in the way of assets, basically just a house. Value of the house is about, we would estimate it about $250,000. And my mother specifically, in the will, dedicated the house to one of my sisters, the sister who was taking care of her, towards the end of her life. And I, when I guess the question is does that probate at all? I mean, we do have an attorney that kind of read us the will and stuff, but we didn't get very much clarity on this situation. And
if the house is in a deceased person's name, there'd be a petition to determine homestead. Basically, the personal representative would be appointed, and the personal representative can sign a new deed out of mom's estate to her if that's what the will says. So, yeah, there is a probate process to be able to transfer the homestead. There's a probate process.
What our situation is that, we really need to liquidate the house because she's got a HELOC against the house, and my sister, who is in the house and really is the one who's going to take the house. We're all fine with that. She needs to liquidate it to, resolve debts with that my mother left behind. And
see, the homestead, though, the homestead is free from the claims of creditors, except for the mortgage.
Well,
so it doesn't have to be liquidated to pay credit card bills or other things like that.
Gotcha. Okay. Well, but she the only way she's going to be able to handle the HELOC is to sell the house, pay off the HELOC, and then walk away with whatever's left over.
Yeah.
But you're saying that's separate from the...
Well, that's part of the probate. I mean, once this house is deeded to her, she can certainly sell it.
Okay.
Or she could sell it.
And the probate takes a couple months, right?
Oh, at least. Yeah.
Yeah. So we're not going to be able to sell the house quickly. We got to wait until all that happens, right?
Well, I think you could sell it within, say, 90 days once the creditor periods pass by to make sure there are no other creditors that would have some impact.
Okay.
But her attorney should be able to, since you're not represented by that attorney, since you're a beneficiary, I can talk to you. But if she called me, I really probably couldn't advise her because she has an attorney. But her attorney should be advising her exactly what to do and how to do it through the estate process.
Okay. Yeah. All right. Well, so as far as the, this is another question. I don't know if I can keep you on the phone this long, but my mother had like 3 different sources of income. She had Social Security, she had a work
pension.
Mm-hmm. Yeah, and a military. I don't know what it was called, retirement. My father's retirement or whatever it was, armed services. So she had like 3 sources of income, and she died like the 29th of the month, and then these checks came in on the 1st of the month, and my sister, grabbed the money from my mother's account, and now they're saying, oh no, you got to give that back.
Yeah, if she wasn't living on the 1st of the month, she probably has to return that money.
That's it. Okay, yeah, that's what's happened. Okay.
All right.
Yeah, thanks.
All right, thanks for calling. I'm sorry for your loss too. All right, you're listening to Ask an Attorney all about Florida law. We had a Tim in Largo. You were going to be next, Tim, so if you want to call back, please do. A few people dropped off the phones there, so during that call. 877 is the toll-free number. 877-943-9673. That's 877-943-9673. Going back to that first little bit of information Patrick Smith gave us about probate. Attorney Patrick Smith with their firm. So, it's a shame that gentleman died, and what happens to his estate? So if you never can find any heirs, eventually the state of Florida will wind up with that money, probably go into the school fund or so forth. And if he had a favorite charity, if he didn't have any relatives, maybe he had friends he could have left it to, or maybe a favorite charity he could have left it to. He could have directed where it went, just never got around to it. I guess you just assume a person like that doesn't care what happens to their estate, but in most of the cases that's not really true. They do care. They just never got around to it. Let's go to Tim in Largo.
Morning, Joe. Thank you for taking my call.
Hey, Tim, my pleasure.
I've got a friend who has asked me to officiate his daughter's wedding. My understanding in the state of Florida, or Pinellas County, once you receive your marriage license, you're sort of officially married. Are there minimum requirements for somebody to officiate somebody's wedding? I'm not a clergy, and I'm not a...
You're not a notary?
Correct.
Well, now I've officiated in my career, let's call it 3 weddings. But I'm a notary, so I was able to do that and then notarize the document. So I believe you're going to have at least to have a notary present during the ceremony.
Okay.
So you might be able to officiate, but you're going to have have a notary present to be able to sign it. And you can go online and probably find a mobile notary that would be willing to show up and notarize the papers.
Okay.
You could officiate the wedding ceremony at the courthouse. They have they marry people down there, and they the clerk of the court signs it. You can if it's going to be is it going to be in a church? The church probably is.
No, and this is where I met the gentleman, was at church, and he attends periodically. He has reasons. It's for, I assume, not selecting somebody that is currently clergy at the church. He's just chosen me. I guess he's fond of me, and
hey, you could do it. You could marry him in my conference room, and I'd notarize it. I mean, you figure out a place to do it. So
he's okay. We'll do. He's planned some type of an event at a large place in Tampa. So either become a notary or have a notary present. Do you believe will fulfill the obligations of the law?
What's the last thing you said?
Having notary.
Yeah, have a notary
present.
Yeah, have a notary present to notarize the papers, the marriage papers.
Okay, I appreciate that. Thank you.
All right, thank you. All right, you're listening to Ask an Attorney. The 3 marriages I did was a next-door neighbor, across the street neighbor, got married. That was my first one. Second one was on the beach. A couple that we know, friends, were getting married on the beach. We had a beach ceremony. And the third one was actually they rented time in a church. So I officiated the weddings and was the notary. Actually, it's kind of fun. It's kind of something I hadn't ever done, and I enjoyed doing. I knew of all of these three couples, well, and enjoyed being asked and being part of their life and part of their marriage. All right, let's go to James in Riverview.
Hello.
Hey, James.
Hi. Thanks for taking my call. My question is, I remember listening to you last week saying that you are a concealed carry permit holder, and so am I. The question I have is, if I apply for a legal marijuana card, do I have to give that up?
No, you don't. I've had this question before, and I've had one of my attorneys that it was more familiar about that question than I was, and asked him, and he said no. So I don't think one doesn't prevent the other one. So if you have a concealed weapons permit, you don't have to give it up if you get a marijuana card for health reasons.
Correct. Great. Okay, that's my question. Thank you so much.
All right, thank you. All right, phone lines are open. If you have a legal question, you have a toll-free number, which is 877-943-9673. That's 877-943-9673. If you have a legal question, it can be just about any area of law. It can be about wills, trusts, probate, guardianship, power of attorneys, healthcare surrogates, personal injury, premarital agreements, postmarital agreements. If you have a legal question, 877 is the toll-free number, 943-9673, 877-943-9673. Let's go to Charles in Clearwater.
Yes, sir. Again, thank you very much for, first off, being on the air. You are a wealth of information. My question is very simple. A friend of mine is in the hospital. He requests a POA and wants me as a power of attorney. Do I have to file that in the courthouse?
No, sir.
All right.
Well,
so
let me qualify that though. Generally, you don't have to qualify a power of attorney. Once in a while, someone where you want to use it once filed and has a certified copy from the court that it's been recorded. That's fairly rare, but generally, I say most of the time you do not have to file a power of attorney with the court.
Okay.
So do you have someone to prepare the power of attorney?
No, I don't.
Okay. Well, we're asked to do that all the time, and we if we can get into the facility or the hospital, we go and send a notary, because it has to be notarized.
Yes, sir. I understand that.
If the hospital's not allowing visitors, then we work through the hospital administration to see how they can arrange for a legal document to be signed.
Mm-hmm.
If the person's in a nursing home, they have usually the nursing homes in assisted living, they have some type of system to set up to where they can accommodate legal documents being signed. But
this is an individual at a veterans hospital. So, and I understand that your office is on East Bay Drive. My question is now concerning a time frame, because they just pulled 4 liters of liquid out of his lungs in the last 2 days.
Okay.
And I'm afraid that he may not be around much longer. His family's not in the state, and they insist that I be a part of his ability to, shall I say, boots on the ground.
All right, so let me tell you this, though. Power of attorney document is void upon death.
Oh, okay.
So
right.
A power of attorney document is important during his last days, of course, to be able to maybe make some decisions, including healthcare decisions. But also important would be the last will and testament or trust, depending on what kind of assets he has.
I believe he has a trust. Okay. That helps me out a great deal.
All right. Well, let me tell you this: if he has a trust, are you the first successor trustee?
No, I have no accessibility to that whatsoever. His family is up north, but again, because of their health issues, they're unable to control any of those assets here.
Well, here's how things work. Let's suppose most of his assets are in the trust, and somebody needs to get to those assets. The next person he named, the first successor trustee in line, would have to get 2 doctor's letters to say he's not able to handle his finances, and then they would be in charge of the estate. If all of the if all the successor trustees are family members who don't want to be trustee or can't perform the job,
Unable.
if it's anything like my trust that I do, the trustees can resign. The successor trustees can resign. You get a doctor's letter that he can't perform the services, and a majority of the beneficiaries can appoint another trustee.
Mm-hmm.
So you have to see if you can find this document, because that would be very important, I think, at this stage.
Okay.
And then figure out
thank
whether.
you again.
All right, no problem. All right, thank you. All right, you're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The law office is open. Love to help you. We're about halfway through the show. You have a toll-free number, 877-943-9673. All right, let's go to Christy in St. Pete.
Hello?
Hey, Christy. What can I do for you?
Yes, I just moved from California to Florida. Came home to Florida. Hang on one second. Let me take you off the speaker. Hello. And I owned a gun in Florida. I still own it. California, and I still own it. What is my responsibility in registering that here now that I live in Florida?
There's no formal registration of weapons in Florida.
Oh, okay.
Do you have a concealed weapons permit?
I don't. I wouldn't mind getting one, but I just have it for I hope I never have to use it, but just for protection in the home. So I just didn't know what my responsibility was.
No, you don't have to register a weapon like that.
Okay, great. Awesome. Well, thank you for that. I appreciate it.
All right, thank you.
All right. Great show. Bye-bye.
Thank you very much. Let's go to Sarah in Clearwater.
Hi. Good morning. I have 2 brothers on a trust,
Mm-hmm.
and the situation here is that the older brother, who's the fiduciary, I guess,
Mm-hmm.
he added his wife onto the house, and
Okay, hold on
he
a second.
didn't.
Okay, hold on a second. So you have a trust.
Yeah, well, I don't have the trust. My mother left the trust.
Oh, your mother had a trust.
In
Okay.
my brother's names, the 2 brothers, her 2 sons, and the elder brother put his wife on the deed of the house, and and he didn't inform the younger brother that he was doing that. And when the younger brother went to file homestead,
Mm-hmm.
because he's going to be living in the house, he went to file homestead. They said there's someone else on the house. Can that person do that, or are they violating their duties as a fiduciary?
All right, so your mother died, I assume, right?
Yeah, she died 4 years ago.
4 years ago. And her son became the trustee of her trust.
Yes.
All right, so were the assets distributed out of the trust? Was it 50-50? Did they do a deed 50-50 to the 2 sons?
Right.
Okay, and then one son took his half and put his wife's name on his half. Correct? Am I following it?
Actually, the fiduciary is handling a savings account, and he's handling the estate. And the younger brother's going to live in the house.
Okay, I got all that, but you need to follow my question.
Yeah, but
the house came out of the trust to them 50-50 to the 2 sons. Is that correct?
Right, that's right.
And then the one son decided to put his wife's name on his half. Is that correct? And your
right,
question is that was that a proper thing to do? Is that your question?
Right.
All right, so the son who owns half can do anything he wants to with his half. So yeah, he could put his wife's name on his half.
But then on another call, you mentioned that person can also go and make another trust and put his wife on it. Is that possible?
The son with the wife could create their own trust and put their half interest in that property into their own trust. Yes.
And they live in Michigan, and the house is in Florida.
So the other son is only going to get half of the homestead exemption. So
but he's not supposed to add his wife on there.
No, ma'am. You weren't listening. He owned half. He can do whatever he wants to with his half.
Oh, okay. His reasoning is that when he dies, he wants his wife to get the half.
Yeah, he can do whatever he wants to with his half. So it's perfectly fine that he put his wife's name on there.
It's perfectly okay then?
Yes, ma'am.
Because that's not what my mom would have wanted, but because she put him on there, he can do what he wants.
He owns half. He owns half. He can do whatever he wants to with his half. And so they're going to follow the four corners of Mom's document. She gave him half. He can do whatever he wants to with it.
Oh, okay.
All right, Sarah?
All right. Thank you.
All right. Thank you for calling. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open for your call on Saturday mornings at 8 o'clock, 8:02. And if I can help you in any way, that's what I come in for. We have 52 minutes. We have 23 minutes left of Ask an Attorney, all about Florida law this morning. You have a toll-free number, 877-943-9673. Let's go to Steve in Jacksonville.
Hey, Joe. How you doing this morning? Thank you for all you do.
My pleasure.
Question for you. If I sell my home in the state of Florida, do I have to pay some kind of a capital gains tax?
No, you have if you sell it while you're living there, you have, if it's sold while you're living, you have a are you married?
Yes, sir.
So you basically have a $250,000 each exemption.
So it'd be $500,000.
Yeah. And if you bought another home, if you rolled that over into another home, you can go from one home to another without paying the capital gains tax as well.
Oh, outstanding. Well, you answered everything I wanted to know. Thank you very much for your service.
All right, thank you. My pleasure. Toll-free number for you to call the show, 877-943-9673. It's kind of fun sitting here when you know the answers. It's not quite as fun when you get a question you don't know the answer to. But hey, I don't mind saying I don't know. I don't know everything. And if I don't know, I can help find the answer for you. I'd love to help you at 877-943-9673. Let's go to Larry in Jacksonville.
So, thank you, Joe. I really got a couple of questions. One, I wanted to find out if the three people you married, are they still married?
If what now?
The people you married?
Oh, married. Yes, they are.
They are. Great.
They absolutely are. My next-door neighbor right across the street, still happily married. I kind of played a little joke on them. I told them my notary stamp had expired right after they were married. Just joking, though. It wasn't.
That's cool.
And then the couple on the beach, we still have dinner with them socially and enjoyed their company. And the younger couple, actually, it was we had good friends, and their son wanted to get married in a church. And so they rented this little church in Dunedin, a little chapel. I forget the name of it. We rented that, had 50, 100 people there, and we had a great time together. And they're still happily married. So yeah, they all three of my couples that I married are happily married.
That's an honor. My question is, there are two sisters. Mother died. She wanted the two to live together, if not to sell the property and split the difference. But the one who lived with her for a long time refuses to do anything, not to move out, not to sell, and won't allow the sister to live with her. So they have to get an attorney to do a forced sale.
Yeah, you do a partition sale.
It's called a partition sale.
Yeah, one can force the other one to sell.
Is that a difficult, expensive process?
Well, I'm guessing it could be $3,000, $4,000, $5,000. But I'm not. You can shop around for attorneys, and you probably get different quotes from different attorneys. But
Well, it's a little complicated.
Yeah.
The tax appraiser's office has stamped a lien on the property for non-exempt. They paid the taxes in the mother's name. Neither has ever owned property, and if they both filed, they would have qualified for a full exemption. But now there's a $21,000, $30,000 lien on the property.
Because
they didn't know to file for homestead exemption.
Right. Well, it sounds like they never transferred the property to their names. It's still in mother's estate?
That's correct.
Yeah. Well, see, they should have, when mom died, they should have gotten an attorney to transfer it to the both of them. That would have, and they both could have, if they were both going to live there, they could have gotten a full exemption.
The question is, can they litigate that and get that homestead exemption lien removed, because they both qualified for exemption, but they just didn't file?
They might be able to convince the county that they live there. You know, the property vested in them upon mother's death, and they both live there, and see if the county can negotiate something with them. So
Gotcha. Okay.
That'd be probably worth doing.
Last quick question.
Yeah. So the mother wanted them to live together.
That's correct.
And that was stated in the document?
I was a notary. She had a will. She said, Larry, I just don't want to do it right now. Can we do it 2 weeks from today? And I said, sure, anytime, call me. And she died within the 2-week period.
All right. You have another quick question? I got a couple of people waiting here on the...
Yeah, quick question. Got a will that's about 20 years old, signed and witnessed by 2 people. Is that sufficient? It wasn't filed in court or anything. Is that sufficient to transfer a title?
No, well, a will is not sufficient to transfer a title, because if you die with a will, you die with assets just in your name, and if they're in a deceased person's name, the will has to be followed, but through the probate process.
You got to go through probate. That's all I needed.
All right, Larry. Thank you. All right, let's go to Chris in Tarpon Springs.
Yeah, hi. Thanks for taking my call. I've got 2 traffic questions. Do you do traffic?
I probably should be able to answer your question. I don't go to traffic court, but I have somebody I refer to those cases.
Yeah, one is there's an intersection with a curve. There's a road with a curve, 2 lanes and a turn lane, and on that curve is another road hitting it. Okay, and when you cross over that to get through the opening in the island to go the opposite direction, okay, you cross the outside lane first, but someone coming around the corner catches your tail.
Mm-hmm.
Now, is it strictly the person crossing's liability because they misjudged the timing, and they don't know if the other person braked or was speeding because it was dark? Okay.
If they hit you on the backside of your car most all the time, then they were driving too fast or not being careful. If they hit
the problem is that they had just changed the speed limit from 35 to 45. I don't know if you know the area.
Yeah. No, if they hit you from the back, I'd say you're going to have a hard time proving you weren't liable for not driving too fast or following too close.
Okay, no, I wasn't the one that hit the cross.
No, I'm just saying. I meant you, the person that was driving. So.
Okay, because I got caught in the just behind the wheel well. It just caught the very back of the wheel, but the last 3 feet. But I felt guilty. So I right away, because it was a little old lady, so I right away said, oh, it's my fault. I crossed over and I didn't go fast enough. But then I started thinking, wait a minute, I haven't seen any skid marks. I didn't hear any brakes or anything. So was that something that I should go to court? And because I started thinking, I got a careless driving ticket, and I think that's like 6 points, or is that 3?
If you want to call me, I'll give you the traffic attorney that I would refer the case to. You can discuss it with him.
And then a second question is, you know how your medians go up to an intersection, okay, up to 19, and the island ends, and then there's about a 10-feet space, then a 10-foot painted walkway, then another 10 feet before you're into the lane of 19. So you got 30 feet. And there's no U-turn, okay? Can you make a turn within that space between the end of the island and the crosswalk? So you're far from, you're another 20 feet. Or
you mean a U-turn?
Yeah, a U-turn, but you make it right along that island in that gap that's between the end of the island and the painted crosswalk, which then there's another 10 feet. Then you're into the first lane of 19. Okay, make that U-turn there.
Where's the no U-turn sign?
There is no U-turn sign. You can make a legal U-turn.
Oh.
The problem is there was a red light, but it was 30 feet away from the end of the island. So it's kind of like I'm kind of related to like you have an opening in an island way before an intersection, you make a U-turn. Does that qualify, that space between the end of the island, the 10-foot crosswalk, and another 10-foot space? Are you far enough away from the 19 that you're not really making an illegal U-turn for the stoplight because you're 30 feet from the stoplight, 20 feet from the stoplight?
So you have a little side curve road you could take before the intersection? Is that what you're saying?
Oh, this is just a straight-on road to the intersection.
I tell you, I'd have to sit down with you and draw a picture, I think, to understand exactly.
Well, just perpendicular to 19.
Yeah,
the island ends 30 feet before, Okay.
Can you just call me off the air so we figure it out there?
Okay, sure.
All right, thanks.
Uh-huh.
All right, let's go to Carol in Jacksonville.
Good morning.
And Angela, you'll be next. I think I took you out of turn, but go ahead, Carol.
Okay, I have a question. When my husband dies, and then when I die, or vice versa, we have 3 daughters, and we stipulated that 2 of them would get 35% of the estate, and the third one would get 30%.
Okay.
And I want to change that to equals a third, a third, a third. So do I have to have a whole new will drawn up, or could they just somebody just
No, we could do so. An attorney could do a codicil to the will.
Codicil?
But
okay.
Let me tell you, I charge the same thing for a codicil as I do a new will, which is like $150. So it'd be better just to do a new will probably instead of a codicil.
Okay. And do you have an office in Jacksonville?
I do.
And where is it?
It's in It's in Ponte Vedra. Let me give out my toll-free number so other people are listening in other areas, and it's just going to.
Okay,
so
great.
It's 1-800. 226.
Right.
3529.
3529.
Yeah, I'll be in Jacksonville on Friday. So
okay.
I could see you there.
But
if you like.
is it only on Fridays that you're there?
I come to Jacksonville every other week.
Okay.
So
great.
I'm either there Thursday or Friday, and I'm meeting a client Saturday morning in Jacksonville next week because they work during the week and wanted to meet. So they're just meeting me at the radio station in Jacksonville. So you just give me a call and I'll work something out with you. I'll be glad to.
Oh, great. Thank you so much. Thank
right.
you.
Thank
Bye-bye.
you. Bye-bye. All right, let's go to Jerry in Clearwater.
Mr. Pippen, thank you for taking my call. I'm calling in for a friend of mine. He recently went to purchase a firearm. He has a concealed carry permit, and he recently got a medical marijuana card so he can, he uses it as a sleep aid.
Mm-hmm.
And on the paperwork, they asked him if he had a medical marijuana card, and of course, he's an honest individual, so he said yes. And they declined him because he had a medical marijuana card.
Really? Well, that's kind of contrary to one of my first questions this morning. So he had a medical, then he wanted a concealed weapons permit, and he was denied because he had the medical marijuana card.
No, he currently has a concealed weapons card.
Oh, I see. Oh, and he went to get the marijuana card and was declined.
So he has both cards, a medical marijuana card and a concealed weapons card. He went to purchase, so he currently owns firearms. He went to purchase a rifle. And when he filled out the paperwork, they asked him, do you have a medical marijuana card? He said yes.
Oh,
so
I see.
He currently has both cards, yes.
All right, I got you. Well, that's interesting. I haven't heard that before. So the question would be, does he have a legal right to buy a weapon? And was there anything he could do about being denied because he had the medical marijuana card? That's a great question. I'm going to have to find the answer to that out.
Okay.
And I'll call my attorney friend that will know the answer to that myself, and maybe I can. If you call back next week, I'll have an answer for you.
Fantastic. Thank you. I appreciate that.
All right. Thank you. All right. Let's go to John in Clearwater.
Hello?
Yes.
Yeah, the reason I'm calling is that we have some rental property, and one of our tenants died the other day. And there's, from what I understand, they have to have a will for me to turn over the property to the people. Yet I had talked to the tenant before he died. He had stage 4 cancer, and he had told me that who to leave, who was going to be in charge of getting his stuff and taking care of it. And his sister was coming down from out of state and whatnot, and his girlfriend who was here, the one that he's left in charge, he gave the power of attorney to. I'm trying to make sure what my rights are, so that, and given the property, make sure the property goes to the right people, but what I have to do to cover my tail. Because I want to try and, according to the law, I'm supposed to have a copy of a will.
Yeah, a copy of the will and a copy of the appointment of the personal representative by the court that was nominated in the will.
Yeah, and I got the power of attorney, but the power of attorney upon his death, I already knew, even before he said that earlier, that upon his death, the power of attorney was no longer in effect. What I'm wondering is, how do I cover myself to make sure, because I got a verbal statement.
No, verbal doesn't. You can't rely on verbal. You can't rely on verbal. So
I understand that. I understand.
So you want an official copy of the personal representative appointment of the personal representative named in the will.
Yeah, but what if they don't have a will? Then where am I at?
Then like my very first conversation with Patrick Smith, you can file to be appointed the personal representative. If you're a relative or interested party, you can file to be appointed the personal representative of the estate to have the power to deal with the exact same things you're talking about in your question here.
Okay. Well, the problem is I'm the landlord. He was renting from me, and he died. You know, I just want to make sure it goes to the right people. And I don't want somebody coming back 6-7 months from now saying that they're a relative of his. Where's his stuff?
Yeah. So
you follow him?
Yeah, I understand. Yeah. So they need to vacate the. You know, if you could get affidavits. Did he have children?
No.
No spouse, no children?
No, just I think he has a sister. And the girlfriend, they left the power of attorney and everything.
Well, the power of attorney, forget the girlfriend, the power of attorney is void. So if he had one sister, he had no spouse and no children and no parents.
And a nephew. He's got a nephew too up north. That's supposed to be in sometime today or tomorrow.
All right, but if he only had one sister, that was his closest relative, and no other siblings.
Correct.
And she would sign an affidavit that she's the only sibling. Well, see, the problem is you think he doesn't have a will, but a will could show up.
That's what we're.
Yeah, see, a will could show up.
Have a will.
Yeah.
Yeah, they said they had a will, but they hadn't been able to find it or whatever. Right now, they're still looking for it.
Yeah.
And that's the problem. I just want to make sure. Because I don't want somebody coming back, like I said, 6 months from now, say, well,
yeah. So you got to wait till hopefully the sister, regardless, will try to get herself appointed the personal representative. And then you have that court paper, then you can release it. Otherwise, let's say if they find a will, you entrust everything to the sister, she sells it, and then the girlfriend comes up with a will where everything was left to her, you're in trouble. So you wait for a court appointment. Okay?
Oh, shoot. Okay, I guess. Hell, that's going to cost me money then, right?
Well, maybe not, because you can put a claim on the estate if there's money in the estate.
Okay, well, yeah, his rent and everything's paid up. I mean, he was a good renter, a good guy.
All right.
I just don't. I want everything to be done as close to what he told me he wanted done.
You have to follow what's in writing, though. Don't rely on verbal. You have to follow what's in writing.
Right, I understand that.
All right.
All right, I appreciate it and see what we can do on it.
All right, John.
Thank you very much.
All right, thank you. All right, let's go to David in Tarpon Springs.
Hello, Joe.
Yes.
My brother, he passed away and he wasn't married, and his money. I'm the only one left. Could I get some of that money from him or not? Of his estate?
Did he have a will?
He passed away.
Yeah. Did he have a last will and testament?
No, he didn't have a will.
All right. So he had no spouse and no children.
Right.
And you're the only sibling?
Yes.
Yeah, we could probate his estate, and it sounds like you would get everything.
Yeah, I had to two of my relatives, brother and the sister, they signed the paper and they got about $500, but I don't remember signing any paper.
Oh, okay, so you're not the only sibling.
Yeah, I'm the only one left.
Okay, so he had deceased brothers and sisters?
No, I'm the only one left.
But did he have a sibling that passed away?
No, he didn't have any.
Okay, you're the only sibling. Well, you should be entitled to everything that's just in his name.
Yes.
So I'd be glad to help you, or find an attorney that can help you probate his estate.
Yes.
All right?
Yes.
All right, David. Thanks for calling. Sorry for your loss.
Okay, thank you.
All right. Hey, we only have about a couple of minutes left. If you'd like to contact our firm, we have a toll-free number. We have multiple offices in Florida, 2 in Pinellas, 2 in Hillsborough, 2 in Pasco, offices in Lakewood Ranch, Lakeland, Davenport, the Villages, Clermont, Leesburg, and offices between St. Augustine and Jacksonville, in Trinity. We have offices, we have like 15 office locations around Florida. If you'd like to contact our office, there's no charge for the first appointment. You have a toll-free number, 1-800-226-3529. That's 1-800-226-3529. If you'd like that poster sheet, estate planning poster sheet, I'd be more than glad to send that to you. You'd like a link to our Zoom seminars, educational seminars on trust, probate, gun law, family law, Medicaid, asset protection, just send me an email to Joe, Joe, at attypip.com. That's Joe at attypip.com. All right, so we have, let's go to Craig in Clearwater. Craig would probably have a minute.
Hey, thank you very much for taking my call. I am receiving a beneficiary from a friend in New York that passed away for $50,000, and I'm wondering if there's anything I should do in particular to protect that gift, that benefactory that she gave me. The attorney that's handling the case did contact me. At first, they didn't give me any paperwork. I asked for it, and she sent me a copy of the will, and I am in the will for the $50,000. They're liquidating her assets right now in New York City. They said it'll take some time, and she did mention that it may not be enough money to pay everybody, so it may be less than $50,000. So that's the flag I was a little concerned with.
Well, if the debts exceed the amount of money to be distributed, then they just prorate the amount. So they might prorate your amount of...
amongst...
Sir?
Sorry. No, I said, I'm sorry to interrupt. I was wondering if that would be evenly distributed. There were about 50 people she was giving to, including universities and other individuals as well. And most of them were a lot more money than me.
Well, the dollar amounts come off the top, and if the balance of it is percentages, and there's not enough money to do the dollar amounts, and it's prorated.
Okay, great. Evenly across the board?
It's prorated in the percent of money that you get.
Yes. Okay.
So,
and then that would be the same prorated ratio, I suppose, for everyone involved?
Well, the people that are at the bottom of after you get through the dollar amounts, the percentages might not get anything. They do the dollar amounts off the top.
Oh, really? Okay. Is there anything I can do to be represented to sort of, assure that I do get the money or some of it?
Yeah, well, you can meet with an attorney. You could call me, and I can go walk through that with you if you like.
That's exactly what I'll do. I'd be glad to do that.
All right,
Thank you very
Craig.
much.
All right, thanks for calling.
Thank you for your services.
Thank you. You're listening to Ask an Attorney, all about Florida law, every week, Saturday mornings, 8 o'clock. Join us again next week. You have a great, great week, and so long.